the case of Swift and Carpenter has been anticipated for some time. It was a case that started with an accident on the 13th of October 2013, where Charlotte Swift was being driven by her then partner along the M5. There was some sort of accident, don't know the details, but she suffered devastating injuries in the form of the amputation of the lower part of her left leg and serious disruption to her right foot. And the case came to trial in the middle of 2018 before Mrs. Justice Lambert. She awarded lump sum damages of just under £4 million in the case. And she found as a fact that as a consequence of her injuries, Charlotte Swift needed additional accommodation to the value of £900,000. She lived in central London. But she went on to find that she was bound by the decision in Robertson Johnstone and therefore awarded nil damages under that particular head of loss. Now, as I'm sure most of you are already aware, the Court of Appeal came to a different decision in the end and awarded Charlotte Swift £801,000 in place of that £900,000 special accommodation claim, representing about 89% of the capital value of the property that she needed. And they did that because the Court of Appeal held that Robertson Johnstone no longer provided fair and reasonable compensation for claims of this type, such that a new methodology needed to be devised in order to cater for the patent need that arises in accommodation cases. Now, as I say, this Court of Appeal decision has been long awaited. I expect that most of you, and certainly those of you that have practices that routinely involve accommodation claims, have probably already read the judgment, or if not the judgment, you will have read summaries of what the essential findings were already. That might not be true for all of you, but for that reason, I'm actually going to gallop through at some pace the judgment itself, starting with the history moving forward. I am going to do that quite quickly because it's going to take too long to do that in detail. And the much more interesting part of this presentation really lies at the back end, where I will seek to examine what flows from the case, both in terms of practicalities and, more importantly, questions that haven't really been properly yet considered, or questions that will inevitably play out as the result of this case. So let's make a start. We've got the old law. The original case actually wasn't Robertson Johnstone. It was a case called George and Pinnock. But most of you will be familiar with the decision in Robertson Johnstone, which essentially held that you can't just award the full capital value of a new house to a claimant, because that would be to overcompensate them. When they die, the value of that house will be passed on to the family and the like, and they will gain a windfall. And so the decision in principle was to award an amount of money which in effect compensated for the lost investment potential of the extra capital required. The thinking being that the claimant would borrow from other heads of loss, for example, pain, suffering and loss of amenity, to make up any shortfall that she wasn't otherwise awarded beyond the lost investment potential, so that effectively the thing worked. The claimant could buy a house given the nature of the awards when looked at as a whole. And if we look at Charlotte Swift's case, but we wind the clock back to 1992, you can see that her old property was worth 400,000. Okay, that's modern property prices. She needed special accommodation of 1.3 million, differential 900,000. So that's the bit the court is looking to compensate for. She was 45 years old at trial. So back then, discount rate was positive. It was about 2.5. So her life multiplier would have been 23.82. 2% is the loss of what the court held in Robertson Johnson to be the annual value of her lost investment potential. Multiply that by the 900,000, and the award that comes out, £428,000. So that's what probably would have been awarded to her had this case been heard in 1992, but with 2020 property prices. Of course, accommodation claims also include other elements. I'm not going to go into those, but later on, Betterment is a feature that we'll come back to look at. This slide, I suppose, should have been called the decline of Robertson Johnson, because what's happened over time since Robertson Johnson was decided is that property prices have rocketed. And they have by far outstripped the degree to which awards in general damages have risen. From memory, I think in George and Pinnock, the bungalow that was required in that case was, I think, about £18,000, and general damages were about £12,000. You can see that given property prices they are at the moment, in the vast majority of cases, the value of special accommodation will be many multiples, sometimes 10, 20 times the value of general damages. I think it's also right to observe that the court has become more scientific in terms of its approach to valuing awards in personal injury cases. Back in the 70s, there were a number of cases, actually George and Pinnock is one of them, where judges seemed prepared to wield the broadest of brushes when estimating the value of various heads of loss. We also had the advent of PPOs, and of course they're a good thing, but they rob the claimant of the big lump sum, and it is that lump sum into which she was expected to dig in order to fund the shortfall in between the damages she got for her accommodation and the actual accommodation. But the real killer for Robertson Johnson was, of course, the negative discount rate. Now, some of you may be aware that after Robertson Johnson came a decision that was reported with Wells and Wells, decision in Thomas and Brighton Health Authority, where the court decided that the appropriate value of the lost investment potential should be tied to the rate of return used to calculate multipliers in personal injury cases. And at that stage, it was the Damages Act was pending, but the court said, look, use 3%. That was used for multipliers, but it was also used for Robertson Johnson, pending the Damages Act coming into play. And so the Damages Act arrived. We had, in June 2001, we had the discount rate moving to 2.5%. And you will then recall that in March 2017, after much lobbying, it did take far longer than it should have done. Liz Truss moved us into the negative discount rate. Now, as soon as the discount rate became negative, Robertson Johnson awards disappeared, because within that equation, if any number is negative, you produce a negative product, and that means nil damages. There was then the decision in JR v Sheffield Teaching Hospitals. That had an accommodation claim. It was decided that there was a need for accommodation, but negative discount rate, award was therefore nil. There was much judicial criticism of that fact within the judgment. An appeal was launched, and just as in Swift and Carpenter, the PIBA intervened. And at that stage, the chairman of the PIBA was Robert Weir QC. And he produced, off the back of his skeleton argument in that case, an article in JPIL, which sought to explore other methods of solving the need for accommodation. And I'll touch on those a little bit later. But what in fact happened in JR was that the case never reached the Court of Appeal, because the NHS blinked and they paid, I think, 90% of the capital value for the accommodation by way of compromise. The claimant in that case was under a mental lacked capacity, and so the award needed to be approved. And at the approval hearing, the decision by the NHS to pay the accommodation claim, or 90% of it, was described as a capitulation, which was an accurate description because that's what it was. Final step. We've had a change to the discount rate more recently, back up to minus 0.25%, but of course we're still in negative territory. So back to the facts of Charlotte Swift. I've covered most of these already. You can see the differential in property price, what was required, 900,000, what was awarded, nil. One of the reason this slide's here really is just to sort of as an opportunity to reflect with some sympathy upon those representing Charlotte Swift, because they have complained rightly that prior to Swift reaching the Court of Appeal, it was claimants were in an impossible position. They could never prove an alternative method of calculating their award for special accommodation, because Robertson Johnson was in force such that they met the impossibility of gaining permission to obtain expert evidence from an actuary, from financial experts, from people, property valuers, people in the mortgage market and the like, so as to try and build a better methodology to present to the court, backed up by evidence, to challenge the case. So we get to the Court of Appeal, and as we all know, there were a number of arguments advanced by the defendant, and this is where I'm going to speed up somewhat, because as I say, I want to get on to the ramifications really of the decision. First of all, the defendant argued that actually the Court of Appeal was bound by Robertson Johnson, because Robertson Johnson is itself a decision of the Court of Appeal. They also tried to suggest that the principles of Robertson Johnson had, if you like, been approved by the Supreme Court in Thomas and Brighton Health Authority. All of those arguments were rejected. Court of Appeal deciding that the decision in Robertson Johnson wasn't one involving a principle of law. It was merely guidance as to how the principle of compensation could be satisfied, in particular regard to accommodation cases. Defendant went on to say that, well, look, can the claimant prove that she suffered a net loss? Their contention being that if you chuck another £900,000 into the property market, you will gain from that appreciating asset. You can rob Peter to pay Paul in relation to your other heads of loss. You can dig into that capital by way of equity release in the future, such that by spinning all the plates in the air, effectively, you can get to the end of your life expectancy without running out of money. And in order to prove that, they called a whole host of experts. But if you read the judgment, you'll see that most of that evidence fell over. It was evidence that was all designed to tell us about the future, but putting it very shortly, the experts generally gave evidence to the effect that you couldn't safely predict the future, or that you had to make a whole host of assumptions in order to arrive at a prediction, and even then it would be inaccurate. And the further point was that by expecting a claimant to dig into their other heads of loss and to put some of that capital into the property market, undermined the entire basis of the setting of the discount rate, which assumed a particular cautious portfolio of investments. So how could the court, if you like, hold the claimant to that? Well, the court, it's not the court that would be doing it, but the claimant would, as a matter of law, be held to it by the Damages Act. how could it be right to undermine the assumptions that lay behind the setting of that rate by requiring the claimant, as I say, to take a chunk of that pot and stick it in the property market? And yeah, so all of that really didn't work. A lot of effort went into it. Unfortunately for the defendant, it didn't work. And what we have then is that the judgment. So look, there are not many of these slides, but I am going to read them because they form the core of the findings in Swift. The main judgment was delivered by Lord Justice Stephen Irwin. His judgment was agreed by Nicola Davis, and there was still agreement, but some nuances from Lord Justice Underhill. But most of these quotes come from Stephen Irwin. It is my view that, in the context of modern property prices in a negative discount rate, the formula in Roberts and Johnstone no longer achieves fair and reasonable compensation for an injured claimant. In my view, it cannot be regarded as full, fair or reasonable compensation to avoid nil damages in respect of a large established need, on the basis that, if all the relevant predictions hold good over many decades to come, there will arise a windfall to the claimant's estate. So a head-on rejection, if you like, of the defendant's argument. He goes on, I recognise the need to avoid a windfall to the claimant's estate if that can be achieved without prejudice to the cardinal principle of fair and reasonable compensation. But to withhold all damages for the purpose of avoiding an eventual windfall seems to me to put a secondary principle before a primary principle, to put the cart before the horse. Now, it's worth stopping there for a moment, because it is quite clear from this decision that the court, in the right case, would just ignore the windfall. If there was no other workable way of providing the claimant with the accommodation she needed, for the sake of taking account of a windfall, it would appear to be the case that the court would have just ignored the existence of the windfall altogether. That's not in fact what happened, but that's the tenor of the judgments in the case. He continued, this appellant showed at trial that she has a need for £900,000, which can only be awarded as a lump sum. Is that to be withheld in total because of a potential capital windfall, very probably to her estate after her death, which will not be valued until then? My answer is no. Such an outcome does not present fair or reasonable compensation. And finally, I fully accept that a windfall should be avoided if at all possible, even if it means a not insignificant reduction in the award. Here the parties have a measure of agreement. Depending on the answers to two questions, they agree that the proper approach is now to establish, as best as possible, the value of the reversionary interest in the incremental part of the property to be purchased. Now, let me just pause there for a moment. I'll go back to that earlier slide. There was a lot of interlocutory work in Swift, and the position that pertained at the appeal itself is that all of the potential other solutions, those that had their genesis in the JR case and continued in the early stages of Swift, fell by the wayside. Sorry, I'll go back. All we were left with was an agreement by the parties that the proper approach was to value the reversionary interest of the enhanced capital element of the purchase. So some of you may recall that the potential other solutions included, firstly, an interest-only mortgage for life backed by a PPO. So the claimant gets to live in a house. She's not gaining any capital benefit from it other than through market appreciation. But the interest on that would be held at bay by a PPO. Problem, no such product on the market, apparently. And so that was deemed to be unworkable. I have to say that you have to bear in mind that Charlotte Swift was age 40. That would have been a very long mortgage because it would have been for life over a very long period of time. It's perhaps understandable that lenders would be reluctant to get into that. I can see that different considerations might apply in short life expectancy cases. And we'll perhaps come back to that because short life expectancy cases are one of the difficulties that still exist, notwithstanding Swift and Carpenter judgment. The second one was a lifetime multiplier multiplied by the mortgage interest or rental payments. This would be a lump sum, if you like. So not a PPO, but the lump sum equivalent of the same thing. Problem is that in long life cases, especially, awards calculated using that method tended to produce an amount of money that was greater than the capital value that they were seeking to insulate the claimant from. And that's principally a consequence of negative discount rates. The value of multipliers has climbed enormously, and so what that means is that even if the multiplicand stays the same, because the multiplier has climbed, the damages lump sum award would climb, and it just outstrips the capital value altogether. So you might as well just pay in Charlotte Swift's case, the £900,000, because using this method to calculate an alternative award would produce more money. Thirdly, there was the question of the insurer loaning the claimant the extra money required, and putting a charge on the property. But somewhat surprisingly, it was said that insurers were not appropriately regulated to undertake that type of transaction. I was somewhat surprised to hear that, frankly. But that is what was said. I can see also, and I put this in the slide, that I can see claimants being a bit uncomfortable about having a long-lasting attachment by way of a legal charge over their property to an insurance company. But however it came to pass, it was agreed between the parties that none of these options was on the table. So back to Stephen Irwin. The question is whether the appellant's argument that there should be no reduction to reflect the windfall should be rejected. And I'll pause there. The claimants were indeed arguing that Charlotte Swift should just be given the 900,000. I'm not sure the degree of force that sat behind that in the way it was put, but that was their position. I think they were arguing effectively that it's just impossible to accurately value reversionary interests, and so that exposes the claimant to the potential for undercompensation. Just give her the whole lot. But the Court of Appeal sensibly declined to go down that route. But in these terms, my answer to that will depend on whether a valid and reasonably workable approach can be reached to establishing the current value of such a windfall. Now, again, that does tend to suggest that in cases where you can't value the windfall, that as it was put earlier, the cardinal proposition that the claimant simply gets the capital amount might be the answer. So, problem is, what is the current value of a reversion? Now, I'm just going to pause here just to make the terminology plain, just in case there's any confusion. Imagine the claimant living in a property. She's the owner of that property, fine. But it's easier to think about this in a case where the claimant has no property at all. So what the claimant has to do, what the defendant has to do, is to buy the entire property as opposed to an additional capital element of it. So assume they have to buy the entire property. In fact, what they've got to provide for the claimant is a house to live in until she dies. So that's what would otherwise be known as a life interest, the right to own or live in the property for your lifespan, at the end of which the property then reverts back to what used to be called the remainder man, or the person who owns the property after you die. And you often see this concept arising in wills, where the husband dies, leaves the house to his wife for life, but thereafter the house passes on to the children. And so there has been a need in the past in relation to those trusts to value the distinct elements, to value firstly the life interest, and then secondly the reversionary interest. And this is what the Court of Appeal was trying to get to the bottom of here. How do you value the reversionary interest of a property? And this is where largely the same experts were wheeled out, and there were lots of detailed evidence was given as to various different approaches that could be taken to valuing a reversionary interest. But the underlying issue was the rate of return that an investor would be looking for when investing in a reversionary interest, because depending on what that rate of return was, of course, you get your valuation. And I'm taking this very, very swiftly. It was very, very detailed, and you can see from the slide that one approach came out at a rate of return of about 6.6%, another came out at 3%. Lord Justice Irwin held, I've no doubt that a market approach must in principle be the correct way to value a reversionary interest, and expressly stating that he was being cautious, held that a 5% rate of return is what is the assumption that should be used in order to value the interest. So let's look at this slide, because this shows the actual mathematics, if you like, of the damages award in Charlotte Swift's case. But for property, 1.45 million, property required 2.35, differential that requires funding 900,000. And if you look, it says Court of Appeal, present value of reversion interest, and then there is some maths which I will explain in more detail in a moment. But if you take the 900k, that's the capital sum that you're trying to achieve. You then take a rate of return of 5%, so it's 1.05, and you then multiply that to the negative power of the claimant's life expectancy in years. So if you like, that is 1 over 1.05 times 1.05 times, you keep doing that for 45.43 occasions, and you will get the answer. The value of the reversionary interest, £98,087. So the award is the capital sum, 900,000, less the reversionary interest, 98,000 odd, award 801,000 odd, 89% of the capital value. So that's how it was arrived at. Now, one of the difficulties with the judgment in Swift is that it doesn't contain a formula. It doesn't contain expressly a methodology for calculating it, written down as I have written it on this slide. But it is accepted by, certainly by the PIBA, they were interveners in the appeal, that this is the correct formula. And as my earlier slide set out, you've got R, the reversionary interest. To calculate that, you take, in my equation, SA, the special accommodation, okay, the new house, deduct EP, the existing property. So that gets you the extra capital that you required, taking one from the other, and then you multiply it by 1.05 to the power of L, and L is the life expectancy in years of your claimant. Now, if you look on this slide, L here, I put in brackets life expectancy T2. So that's Ogden Table 2. That's the life tables for females, obviously Charlotte Swift. If it was a male claimant, you'd be looking at table 1, life table for males. You go to the 0% column and you run your finger along, interpolating if you have to for the right age, and that will give you a life expectancy that accounts for mortality. It accounts for the spread of different possibilities of when you might die, but gives you an actuarial figure for your life expectancy. And it doesn't take account at all for investment return, because you're looking at the 0% column. All it's accounting for is your life expectancy. And that's the number you then use for L in the equation when you go to calculate it. And if you look at the bottom line on this slide, and this is sort of sometimes helpful in getting an understanding of how this works, to think of it back to front. If you took the reversionary interest, £98,087, and you added 5% to it, year on year on year, for 45.43 years, you would get £900,000. So that's putting the equation, if you like, the other way around. But I hope it helps you understand what it is that's being calculated. Okay, so just some basic practicalities. How do you actually do that maths on your calculator? Well, if you're the proud owner of an iPhone and you go into your calculator and then you flip your phone 90 degrees so it's in landscape mode, you will get a scientific calculator as shown on this slide. And I put a red circle. I've actually stolen this slide off of Twitter. Someone else had already done it for me. You can see an x to the power of y function. And at the top of the slide, you'll see what you have to punch in: £900,000, press times, press 1.05, press the XY button, and then you would type in 45.45 and press the plus minus button, which is towards the top right-hand corner, 3 buttons in from the right-hand side. That would turn it into a negative. Then you press equals, and out will pop your answer. So that's a really sort of elementary explanation of how you'd actually set about calculating it. Frankly, I mean, there is some talk, and people have produced some more tables, or are going to produce some more tables, so that you can use, if you like, the facts and figures route to work this out. I'm going to tell you, doing it this way is just easier. You haven't got to interpolate. As long as you've got the figure for L, which you may have had to interpolate to arrive at, as long as you've got that figure, using your calculator is going to be easier than going back to tables, where you're probably going to have to do another interpolation exercise in order to get to the right answer. So yeah, just one, I just want to mention one thing about the L number. That is life expectancy taken at table 1 or 2 at 0%. Take it from me. I actually had to make a specific inquiry of Darrell Allen in order to bottom this out, because paragraph 170 of the judgment is really confusing. It tends to suggest you should be using table 28, but it's just misleading. The apparent discrepancy simply is a function of the nature of the actuarial evidence that was being talked about in the case. So do not be bamboozled by paragraph 170. So what does a rate of return of 5% a year look like? Well, here is a graphical representation of the value of an accommodation claim over time. So on the vertical axis, the y-axis, you've got the percentage value of a property, which obviously stops at 100% at the top. And then along the y-axis, you have, sorry, along the x-axis, the horizontal axis, you've got years. I've taken it up to 100 years. And this is the value of the award. So clearly, if the claimant was predicted to die 5 minutes after the judgment was given, her award would be nil. But if you look at the other end of the graph, if he or she was predicted to live to, say, 100 years from trial, then the award would, near as damn it, be the full cost, 100%, the full cost of the accommodation. There's a purple line on this slide that represents Charlotte Swift's age at trial. And if you follow that up to where it intersects with the red line, and then you move back to the left to look at percentage property value, you're right up there at 89%. So that's how it worked for her. But this slide is interesting because you can see that the way it works is the value of the award climbs very steeply in the early years, and it climbs to a much slower extent in the later years. And that's an important point that you need to hold in mind when we come to look at short life expectancy cases and how we perform the calculations where we need to split up time intervals and so on. It's worth also looking, since we're on this slide, at what this means for short life expectancy cases. If you look at 10 years and move your finger up, you can see you're looking at about 35% of the property value, 37% of the property value, something like that. If you're looking at a 10-year, if you're looking at a 5-year period of life, you're only at about 20%. And this is why Swift and Carpenter doesn't really work for short life cases, because in a 5-year short life case where a claimant needs a £500,000 house, they're going to recover 20% of that, 100,000. How are they going to deal with, how are they going to make that work from their other damages? This is why short life cases are a particular problem. So, graphical representation. Now, Swift and Carpenter does not apply expressly to all cases. So this is going back to the judgment. Again, Stephen Irwin. I accept the submission that of the intervener that this guidance should not be regarded as a straitjacket to be applied universally and rigidly. There may be cases where this guidance is inappropriate. However, for longer lives, during conditions of negative or low positive discount rates, and subject to particular circumstances, this guidance should be regarded as enduring. So you can see I've underlined some of the phrases in this particular slide. Looking at them the other way around, what the judgment is saying is it doesn't apply to short lives. And it's stated more expressly, you'll see in the next slide. It wouldn't apply to higher positive discount rate cases. Well, I think you can forget about that. I mean, I don't think that anyone is suggesting that the discount rate is going to be shooting back up into positive territory anytime soon. So that one perhaps we can forget about. And then finally, subject to particular circumstances. Difficult to know what that means. And it might be said that that gives lots of wiggle room for judges to do things differently from Swift and Carpenter, citing their individual cases having particular circumstances. But where is it? Yes, both Stephen Irwin and Lord Justice Underhill added to their judgment sentiments both similar to this. I would add that I agree with Lord Justice Irwin that guidance of this character should only be revisited in response to really significant changes. And in the case of appellate guidance, which it generally is, it will rarely, if ever, be right for that guidance to be departed from by a first instance court. So, yeah, subject to particular circumstances doesn't mean that judges can start saying that their case is sufficiently out of the norm to allow them to do it a different way, it seems to me. This slide is just Stephen Irwin's point about short life cases. It may be that different considerations and arguments could be applied to that category of case. He's talking about paradigm 3. There were 3 factual examples that were agreed by the parties for the purpose of analysis. Paradigm 3 was a 7-year life expectancy case. and he says that different arguments could be applied. I make no further comment on that and should not be understood to express a view on it. So short lives are out. So that brings me to my very swift gallop through the decision itself. The more interesting part of the presentation now begins, because we have to look forward. What happens now? Well, first thing to say is that the defendant has already applied for permission to appeal. The grounds being that the Court of Appeal shouldn't have departed for Roberts and Johnson. They shouldn't have rejected their robbing Peter to pay Paul cash flow model, and shouldn't have adopted the method of valuing the reversion that they did. I suspect that's an attack on the 5%. And that's due for hearing on or after the 23rd of this month. And who knows what will happen there. I speculate that the Court of Appeal will probably give the defendant short shrift, but the question then is whether someone in the Supreme Court can be persuaded that this is of sufficient interest to warrant the Supreme Court sticking their oar into it. So, yeah, let's look at some different cases, because this is what really draws out the problems that lie ahead, or possibly the solutions that lie ahead for particular scenarios. So I'm starting with short life expectancy cases. Paradigm 3, as I said earlier, was a 7-year life expectancy case. Okay, but there's no line in the sand here. There's no definition of what a short life case is. And I'm going to suggest that if you look at these factual scenarios, that line talking about particular circumstances begins to make a little bit more sense. So look at the first scenario. Imagine a 70-year-old who needs special accommodation valued at £500,000 or extra capital of £500,000, and he's got a 7-year life expectancy. Alternatively, imagine a 10-year-old, okay, who badly injured, needs the same £500,000, has the same 7-year life expectancy. In both cases, the award would be £500,000 times 1.05 to the power of -7, which gives a reversionary interest of £355,000. So the damages are only £145,000. Now, I'm going to suggest that this case would still work for the 70-year-old, but it probably wouldn't work for the 10-year-old. And the reason I say that is because, and whilst the market's very small, the 70-year-old can probably sell his reversionary interest. He gets the life interest, but he buys the property anyway, or he gets the value of the life interest, and he buys the property, robbing his other damages temporarily, but he could then go to the market and sell the reversion. He's 70 years old, he's got an impaired life expectancy, he's going to die within 7 years or so. You might get someone interested in a 5% annual rate of return saying, yeah, I'll buy that reversionary interest, thanks very much. And the value of it would be 355,000, and the 70-year-old chap gets his money back, as it were. But when he dies, he loses the house, and it doesn't fall into his estate. That's workable, it seems to me, if he can sell his reversion. It's a small market. It's difficult to do so, but he might be able to, because speculators in the property market might take the view, I would suggest, that he is going to die sooner rather than later, and we aren't going to be kept out of our money. There isn't sort of too much downside, as it were, in terms of investment risk. Now, take the 10-year-old child. Okay, predicted life expectancy of 7 years, but you're talking about actuarial evidence here. And any of you that have seen the bell curves that sit behind the spread of life expectancies will know that on that curve there are outliers. Now look, I suppose the same could be said from the 70-year-old's point of view, but the risk is a lot higher for a 10-year-old child. What if? I mean, he might live not 7 years, but he might live 17 years. His reversion is much less attractive than the reversionary interest of the 70-year-old. And it might be that for that reason, the court says, no, look, it's just not workable. This child is only getting £145,000 with which to buy a £500,000 house. And because he's got a short life expectancy, the value of his other damages are going to be suppressed, or they'll be in the form of a PPO or something like that, which it can't be dug into. And so a different solution will need to be found for cases of that type. And look, I'm speculating, but I can see that some of those earlier methodologies, such as mortgage interest linked to a PPO, or payment of rent, or the like, will work, because you're talking about a relatively short number of years. The valuation is not going to be greater than the value of the property. It may work. So that's short life expectancy cases. Now let's look at some other examples. First one is split calculation. So let me just take a second to explain the scenario. So imagine a child brain injury, age 10 at injury, age 20 at trial, predicted to live another 30 years to age 50. Had he not been injured, he would have moved out at age 30 and purchased a family home at age 35 for £300,000, jointly 50-50 with his partner. So in other words, he has 15 years between age 20 and 35 when he had no capital injection into the property market. And then at age 35, he'll have put in his share of the 300, which is £150,000, and he would then have had that and for the rest of his life. But now he needs a property worth 750,000. How do you account for the fact that the capital injection comes into that period of 30 years halfway through? On this example, exactly halfway through after 15 years. And I'm going to give you 4 potential solutions which flow from Swift and Carpenter. None of these I'm saying are right and wrong. I'll tell you which is my preferred solution, but it's a really good example of the sort of arguments that we have yet to have in cases of this type. So first way of solving it at A, just ignore the delay in injection of capital. So your equation is the 750, the new house he needs. Assume he's got the £150,000 right now at trial. So there's your capital difference, which is 600,000 times 1.05 to the power of minus 30, his life expectancy. There's your reversion, 139,000. So the damages are the 750,000 house, take off the capital injection, 150, take off the reversionary interest, 139, his award, £461,000. Is that the right answer? Well, I can hear people saying, well, no, it isn't, because you failed to take in, well, you've taken into account the £150,000 from the get-go, and that surely isn't right. So that's the first example. Let's look at it a different way. Let's split the reversions. So reversion 1, if you like, is the reversion on 750,000 for the first 15 years, because there's no capital injection in that first 15 years. So let's work out the reversionary interest on 750,000 over 15 years. That's R1, answer 360,000. Okay, we're halfway there. Let's have a look at the second reversion, so the second period of time, 750,000. This time he has put the money in, so we'll take off the 150,000 times 1.05 to the minus 15. The balance of his life expectancy gives you the second reversion, 289,000. Then your damages are 750,000 less his capital injection, less R1 and R2, leaving him with a miserable £49,000. Now, that is, it seems to me, wrong, because it double counts the reversionary value in the case. That's one problem with it. I think the other problem is that because the reversions are only calculated on a 15-year basis, it keeps the claimant on the steep part of the curve that I showed you earlier, not on the flatter part of the curve, which is if we were calculating it over 30 years, he would get the benefit of. So, yeah, and £49,000 isn't going to enable him to buy a house. That's the other problem. But it's it's arguably a way of calculating it. And people are going to have to give thought to how compelling these different methods are. So let's think of it a different way. Let's not split the reversions. Let's split the purchases. So let's say he buys a house for 15 years. The first one he buys, he hasn't got any capital injection. So 750,000 minus 0, because he's not putting any money in, times 1.05 to the minus 15, 360,000. And his damages for the first chunk, 750, take away the reversion, 390. So that's his damages, 390,000. And then we've got the second part. So let's say he then goes, right, now I'm on to house 2, 700, so same value, 750,000, but this time I've got my capital, so take off the 150, 1.05 to the minus 15, that gets you your second reversion. And the damages then are 750 less the capital this time because he has got it, less that reversion, 311,000. And so you add those two damages together, the 311 and 390, and you get a claimant pleasing 701,000 out of it. Is that right? I don't think it is, because just as before we were double counting the reversions, this way of doing it, if you like, double counts the capital, the 750,000. And it's also not realistic. The claimant only has in his hands one reversionary interest, not two reversionary interests. So I'm going to suggest that whilst you could argue, and I can see this is attractive to claimants because look at the number at the end, 701,000, you can argue that. I suspect that someone cleverer than me, probably a surveyor or an actuary, would be able to pick that apart. So finally, this is my preferred solution to it because it seeks to overcome some of the earlier problems that I identified. And this is where you have a single reversionary interest, but what you do is you give a weighting to the capital injection. So when you work out the reversionary value, you take your 750,000, but you deduct the mean or average capital injection. So for half of his 30 years, he was going to put in 0, and for the other half, he was going to put in 150. So let's take the average of those, 150,000 divided by 2. So you'd be knocking off 75,000 as an average capital injection. And if you then multiply that by 1.05 to the minus 30, you're calculating a single reversion. So there's no doubling up anywhere. You get your reversionary interest, 156,000. And you then deduct, you take your 750, take off the capital injection, take off the reversionary interest, and you get 444,000. Now that compares to ignoring the late capital injection altogether in A, quite probably. The answer to A was 461. This one's a little bit lower. So it makes sense. It's also a single reversion. And I can see that this should be of appeal to defendants because it forces the claimant to account for some of his capital, and it has some suppressing effect on what the value would otherwise be. But look, honestly, I can see that these sorts of things are perhaps not susceptible to barristers coming up with clever solutions, and that what they really require is more expert evidence dealing with arguably better ways of doing it. So that's example one. Example 2 is what do we do about acceleration? So claimant lives in a £150,000 house, needs a bungalow at age 40, costing £300,000. 40 is when the trial is, but he would have needed a bungalow costing £150,000 at age 75 in any event. So the accident hasn't caused the need for the bungalow, it's just accelerated the need for the bungalow. So look, the Swift calculation would be, right, £300,000 bungalow, take off your existing house 150,000, life expectancy of 35 years. Well, it's not life expectancy, but it's the period of time over which he needs the house. It's the difference between age 40 and age 75. So it's not life expectancy, but the term certain in years over which it will pertain. And that produces a reversion of 27,194. If you then work out the damages, so 300,000 for the house, his capital injection at 150, less the reversion, gives you 122,806, as against the house costing, whereas it's most of the extra £150,000 that he needs. And other commentators have questioned whether this is the right calculation in an acceleration house. And what they've said is, look, if you contrast that between other losses which will occur in the future, the award seems way too high. If you're going to have an operation that you would have had anyway in 10 years' time, you don't get anywhere near that percentage value of the operation. But I think the answer to that is simply the difference between the way in which you calculate the losses. One is based on a reversion calculated at 5%, and the other is a loss that is calculated as it ordinarily would in any other pecuniary future loss case on a multiplier running at minus 0.25, which is why you hardly get anything for it. So I'm going to suggest this is right, but would accept that I'm not guaranteed to be right all of the time. And I can see that there are arguments surrounding whether this approach, the Swift approach, is right in an acceleration case. You can also see an argument about what happens if you've got the whole thing being delayed by 10 years. So let's say you've got your Swift and Carpenter calculation, but that's only going to be made for a point of time 10 years in the future. Now, I think you probably could just work out what the accommodation claim will be worth in 10 years' time, and then use what was old table 27, that's new table 35, to account for postponement of the award. And that would use the current discount rate to produce a multiplier of 1.0253. But it's difficult because the whole problem with calculating what the value is 10 years into the future is that it brings into play what happens to the property market in that 10-year period of time. You're not looking just at the value of money, the difference between investment return and inflation used to set the discount rate under the Damages Act. You're looking at the value of property. You're looking at two completely different concepts. So I can see that form of acceleration case, as applied to accommodation claims, is also something that could cause problems. So I'm conscious I'm going for an hour. I am very nearly at the end, so bear with me. Final example, Betterment. You often see this in accommodation cases. So here's the example: £750,000 property needed, current property 150,000, life expectancy 30. But because there are all sorts of things that need doing and the property needs adapting, the evidence is that it'll be worth £50,000 more than the purchase price of 750,000 once those adaptations have been performed. And the question is, where do you give credit for the betterment? What you've got here is the first line is giving no credit for it at all. So 750 less the capital or less the old property 150, 1.05 to the minus 30. There's your reversion. The damages are 750 less your capital injection, less the reversion, 461,000. So that just basically doesn't give credit for it at all. Or you, sorry, I'm just going to modify what I said there. What you could do is you could take the 461 and you could take off the betterment when you calculate the damages. I think there's a mistake in my slide. So you could calculate the betterment at that point in time. There's another way of doing it. This is the one line up from the bottom, 750, add in the value of the betterment, then take off your capital injection of 150,000, calculate your reversion, comes in at, coincidentally, 150,000, and then your damages are value of property 750 less the 150, capital injection less the reversion gives you 450,000. It seems to me that the right answer here is that you have to include the enhanced value of the betterment when you calculate the reversion, because the reality is that when the reversion is sold for that house, the purchaser of that will know that the work's being carried out. He will be valuing the property that he's going to get in his hands, or the value of it, when his reversion that he's purchased comes to fruition. He will be getting the value of the betterment. So you have to include it. But as I say, I think there are arguments about where in the equation you include that cost. Of course, the other thing is, whichever way you want to argue it, whether it gives you a higher number or lower number, the problem is that sometimes it isn't betterment. Sometimes you've got to pay to put a property back into a marketable condition because people don't want all sorts of disability adaptations. So it can be a cost as opposed to a benefit. So pick which one you want and then pick your calculation accordingly. Okay, finally, renters. How do you deal with people who rent? Here's the example. £350,000 worth of special accommodation, life expectancy for 30 years, but the claimant, if he hadn't have been injured, would have rented £600 a month, that's £7,200 a year, times his life multiplier, £224,000. So how do you account for the £224,000? Well, do you treat it like a capital injection? Well, if you do, you would carry out the following calculation: 350,000, the value of the house, minus 224,000, the value of the capitalized value of the rent, times 1.05 to the minus 30, gives you a sort of reversion value of 29,000. Therefore, the damages are 350,000 less the capitalized value of your rent, 224, less the reversion, you get £97,000. Do you do it that way, or do you say, no, you account for the rent in the last line? So you perform a straightforward Swift and Carpenter, 350 minus naught, because there is no capital injection. He was a renter, not a purchaser, times 1.05 to the minus 30. That minus 30 should be in superscript. I've made a mistake there. So reversion 81,000, and then your damages are capital value 350,000 less the reversion 81,000 less the rent that you saved, £224,000. That, in my view, is the right way to do it. Gives you only 45,000. Is that workable? I know, but I think it's fair, because in this scenario, what you say as a defendant is, well, hang on, where was the rent coming from? The rent was coming from his earnings. He's got an award for loss of earnings, out of which he would have had to pay rent. So it's quite right that he digs into that loss of earnings claim to account for the rent he saved. And you do it at that point. You just give straightforward credit for the saved rent when looking at his losses overall. So it produces a lower figure, but I'm going to suggest that is the right figure.